we might as well get started. So you go to a lawyer and you tell your lawyer what you want, and they draft a will for you. You know, a will really is not really alive, like us. Really, it doesn't really mean, I mean, it's obviously you need to have a will, but it really doesn't come alive until you die and someone brings the will to the courthouse to have it filed before the court. So, you know, if you have a will, and we know that property has to move, has to be shown that the person has died and the property is now going to go to the beneficiaries, you do bring the will to the courthouse where you have lived, and you file, someone files the will, your executor files the will on your behalf. And now you have a will that's been recognized by the court. Now the terms of the will have to be carried out. But before that, if you think about it, the person can, before they die, they can change the will all they want. So a will doesn't really have final meaning until after death and someone brings the will to the courthouse and says, we have a valid will of this person. So when you do a will, you usually have a kind of introductory part. It says, I am Ed Zetlin and I'm making my last will and testament. So you're making your declaration of what you're doing. And that really actually should be in there, because you want to put the world on notice that this is actually a will. This is not just some writing that you're doing and saying, you know, I would like for my property to go at some point to these people. No, you really have to say, this is my will. Upon my death, this is where my property goes. That's important. Then you might have a little bit more information. You might say, I have a spouse and I have 3 children. Here are the names of my children. Here are their dates of birth. That's kind of introductory. Oh, and also you would say in your introduction, I'm doing a will, and if I've done any other previous wills, I've revoked them, okay? So you wanna say that if I've done a will in the past, it's revoked. And so that will you did in the past had a date in the past, but now this new will is going to have a new date. So anybody looking at the 2 wills is going to say, well, here's the will, the last will that even though I have a copy of the previous will, the will that we have now has a date after that, and they've revoked it. So that old will doesn't apply. We're only going to use this will. Okay, so it's very important. So you'll see in your will, I, Ed Zetlin, I make a will. I revoke all the other wills that I've done in the past, and now I'm doing my last will and testament. I'm married. My spouse's name is so. I have these children. Blah blah blah. That's kind of the introductory part to doing a will. Okay. Then we begin to get to the part of the will that really says where your property goes upon your death. So what you would say at the very beginning, the first part, is if you're giving specific bequests, I'm giving 10,000 to this person, I'm giving 10,000 to that person, you would say that first specifically. You would say that first specifically in the will. So, and basically what you're saying is, before anything else gets paid, these specific bequests get paid first. Now, along with that, you also can have a clause to deal with personal property, that is tangible personal property. You know, the fancy desk, the beautiful lamp. And you could, if you wanted to, state in your will, I want this lamp to go to this person. I want this thing to go to that person. We don't tend to put the laundry list of items in the will anymore. We've really stopped doing that, because many years ago, Virginia law said, if you have a separate piece of paper and you've put your name on it and you sign it and you date it and you say, this is where I want my tangible personal property go, and you describe the item and you say who it goes to, and you can make a list. Usually what we do in the will now is we say, I may do a list of items outside of the will in which I am designating where particular pieces of personal property go. And so I want my executor to follow that and deal with those particular pieces of property. And the advantage of that is that if you wanted to change that, if somebody died and they're not going to get that property, you can redo that piece of paper and designate it, that tangible property, to go to somebody else. Okay? So, and you would just keep that with your latest will. And when you pass away, your executor should get the original will, and they're going to need the original will. You can't use a copy. It's got to be the original. And have that piece of paper that is dated and signed by you. They're going to then have the instructions to carry out and make sure that personal property goes to that person. So we don't put the laundry list of personal items in the will. You can, there's nothing, you can do it, but because if you change it, you have to change the will. We don't tend to do that anymore. It's just not cost effective. So you would have that personal property, and then you would get to your specific bequest. Now, also usually at the beginning, you could put down burial issues, okay? You could put in burial instructions. My practice is not to do that. I don't put anything about the burial in the will. Why do I do that? Because by the time somebody looks at the will, you're long cremated or buried away. So I don't think it's a good idea to put that information in the will. What I tell people instead, and you can do this, you can make the plans ahead of time. You can even prepay for these things. Instruct people that you know, these are the pre-planning I've done. You don't have to do anything. It's all been done. And I want to be cremated. I want to be buried. This is where I want to be buried. And you can even do under law, you could say, and I've designated this person, and you can sign and appoint this person outside of your will. So you can do that with a kind of, you can appoint somebody to carry out your burial plans outside of the will. And I encourage people that that's how they want to do it. They don't need to put that stuff in the will, because people don't really look at the will until maybe a week or so after death. And, you know, the burial is supposed to happen by that time. So I tend not to put burial instructions in my will. So you've dealt with your tangible personal property, okay? And you've dealt with your specific bequests. Specific bequests can be, and it's usually now we're talking about intangible financial things, money, for instance. So I want this person to get 10,000. I want this person to get 10,000. I want this person to get 5,000. The important thing to know is that if the first things that occur, the first things that are paid from your estate are these specific bequests. Okay, and that's very important to know, because I'll tell you about that in a moment. So that's the first. So if you don't have enough money for anything else, that's what's going to get paid first before the residuary clause. But then after you've made these specific bequests in the will, you're going to have something called a residuary clause. That's the clause that says all the rest of my property goes to, upon my death, goes to X, Y, and Z, goes to my spouse. But if my spouse predeceases me, then it goes to my 3 children or my descendants equally. Okay? So, and what that does is says all the rest that's passing under my will, after I've made these specific bequests, is going to go to these 3 people. So suppose I have a brokerage account with $300,000. Okay. Just a brokerage account, it's not an IRA, it's just some investments, stuff I have. The first thing that's going to happen is the will's going to say, so some of my assets, I've got specific bequests that it's going to come from the brokerage account. But if that's only amounts to $50,000, I still have $250,000. All the rest in my residuary clause, that $250,000 is going to go to the rest, to all the rest. And we don't normally put in, I have this bank account, we don't do that, okay? What we just normally say is all the rest. And we don't put in specific bank accounts because those can change before you die. I don't need to do a will that talks about a specific account. I'm going to say all the rest that's going under my will is under this residuary clause. Okay? So that's how what we call the dispositive, the gifting portion of the will, that's how it works out. So you have some statement about personal property, you have specific bequests that gets paid before anything, and then you have a residuary clause that goes to these 3 people. Also important in all of these dispositive sections is you have to deal with the issue of what happens if the person you're giving the specific bequest to or under the residuary dies before you. If they die before you, what's the executor supposed to do? You have to spell that out into the will. So if you want it, if somebody dies and you want it to go to their children, we use the word per stirpes, okay? It means it goes in equal shares to that person's descendants, okay? So I might say I have 3 children. I give my child Elizabeth 1/3 of my estate per stirpes. That means if Elizabeth dies, her 1/3 that she would have gotten goes to her children instead. And then the other 1/3 would go to my living child, and the other 1/3 would go to my living child. That's how it works. But you have to say, now suppose I don't want that. Suppose I don't want it to go to my children. Then you could say, well, it goes to my other descendants pro rata. So if Elizabeth dies before me, then that share shall lapse, and that amount, that portion of that shall go to my other 2 children pro rata equally. But even in the specific bequest, you have to say it goes to this 50,000 goes to this person per stirpes, or if it doesn't go to them, then maybe you say it lapsed and it's going to fall under my residuary clause. But all that has to be spelled out in the trust. So your attorney's going to ask you, well, if that person dies before you, where do you want your money to go? You're always going to get that question. And you need to have an answer. You need to have kind of thought about that. Most people don't think about that. We attorneys, we're supposed to think about that. Then you might have, even after that, you might have a kind of a wipeout clause that says if all of my descendants, all these beneficiaries, I've died, if that's actually happened, which is like 1 in a billion maybe, then my property goes to these people, or it goes to this charity or something like that. The likelihood of it going there is slim, but since we're attorneys and we think about everything, every possible catastrophe, we want a clause that says that. I usually tell people, pick a charity that you like and we'll put them in the contingent clause. So that goes in there. Final, after that, now we've dealt with all my property, where it's going to go. Well, who's going to handle this? Who's going to actually make sure that the will is carried out? And that is, you appoint, the next clause is you appoint an executor. So the executor is the person that's charged with probating the will, bringing the will to the probate office, the clerk's office in Arlington or Fairfax, going before the clerk there and saying, here's the will. And the clerk looks at it and says, well, it looks like it's all been done properly and it's been witnessed and so forth. So that testator is then charged with carrying out the terms of the will. Now, I'm not going to go into all of that in this lecture. That's a whole other lecture. That's called the probate process. There are all kinds of rules and things that have to be done with regard to that. Today, I'm just concentrating on what goes in a will. But the executor has a job to do. They have to make sure that the terms of the will are carried out, okay? So you'll have a clause that appoints an executor, and you may have a clause that says, if my executor, this person can't do it, then I appoint this person as my executor. Usually in the will, we waive bond. We waive bonding requirements of the executor. Now, a bonding requirement is an insurance policy that the estate has to purchase to insure the estate, okay? So a bonding company, if the estate is worth $300,000, you have to get a bond for $300,000 plus an extra percentage if you don't waive bond. That ensures that the estate is followed through according to the terms of the will. It's an insurance policy. Most people, when they do wills, they waive it. They say, why should my executor pay for that? That's fine. 99% of these wills, we waive the bond requirement. But that has to be stated whether or not bond is going to be waived or not. There has to be a clause that deals with that. Okay, that's the main part of the will. After that, we have sort of standard clauses to deal with other issues. Some attorneys have a longer standard, some have shorter. You're going to need a clause that deals with the executor's powers. So I usually have a clause that says my executor shall have powers, and there's a statute under the Virginia Code that says what the powers are, and I usually say my executor has these powers, okay, to deal with my property. I may have a clause that deals with taxes. So I'm going to have a clause that deals with taxes. it's kind of standard to have it in there. For almost all of the estates and people I do, there's no federal estate tax, so we don't have to deal with that. The executor does have to make sure that Ed died in January, what are we, January 18th. I die tomorrow. Well, I've earned some income since January. I paid my tax. No, I didn't pay my taxes. I didn't file any tax return for 2022. Well, my executor is going to have to file a tax return for 2022. So they're going to have to, and they have to file a tax return for 2023 because I've gotten some payments since the beginning of the year. Not a whole lot, but gotten something. So they're going to have to deal with that. Now, so I've dealt with powers, I've dealt with taxes. I may have a clause to talk about, well, what happens if there's a descendant and the descendant is under 18? What happens to that money? So I have a clause that deals for what the executor, the options the executor has for dealing if somebody is a taker under the will that is a minor. So we need to deal with that particular circumstance, okay? Those are the main aspects about the body of a will. But then we have the concluding part, okay? So a will has to be signed and dated by the maker of the will, okay? And although it should be notarized, that is signed by a notary that says, Ed Zetlin came before me on this day. I saw him sign the will. He was of sound mind. And I, the notary, attest to this. Great. Beyond that is witnesses. A formal will in Virginia should have witnesses. We required 2 witnesses. So in addition, the notary is going to have 2 witnesses that say, we saw Ed Zetlin sign the will on this day before us, and he signed it in front of us, and we're testing to that in front of him. Beyond that, we have an affidavit clause after that. And you, in Virginia, you must have this affidavit to make things work. The affidavit, and there's a statutory language for the affidavit. It's a specific clause that us attorneys know about, and we put that in the will, and that's also signed by the witnesses. If you don't have the affidavit, then really under Virginia law, the witnesses have to come to the probate office and say, yeah, we saw Ed Zetlin sign that will. You were there. Well, how practical is that? That's very impractical. Nobody's, those witnesses may be themselves long gone, or no one can find those witnesses. So instead, we have this self-proving affidavit that if you have that language and it's signed by the witnesses, and they say you don't have to ever bring those witnesses to the probate office. That self-proving affidavit settles that issue. So, but you must have that self-proving affidavit in the will, okay? So that, in a real quick nutshell, let's see how much time we have here, is the formal aspects about a will. Now, one of the things you have to think about is what property is going to pass under the will. Well, maybe no property is going to pass under the will. Maybe all the person had was a retirement account that is an IRA or a 401k or whatever, and the retirement account has a designated beneficiary. Is that going to go through the will? No. That retirement account does not go through the will. It goes directly to the designated beneficiary. So then none of that money is probated through the will. Well, let's suppose then they had a couple of bank accounts, and the bank accounts had a clause that says, upon my death, the bank is supposed to pay to this specific person. You can put that in your bank account. It's called a POD account. You can say, in my Wells Fargo, I have this saved checking and saving, and upon my death, POD, this account goes to this people. Or maybe it's a joint account with your spouse. Well, that doesn't get probated. That's just jointly owned, and it's owned by the spouse upon your death, or maybe a child upon your death. So those bank accounts, they don't get probated either. They don't go through the will either. So if all you had, what you had was this retirement account, and then you had some bank accounts and they were POD, there's nothing that's going to go through the will if that's all you had. Okay. And that's because you have used other methods to transfer your assets to people upon your death using methods outside of the will. Same would be with life insurance policies. Same may very well be for a trust, a living trust, if you put all of your assets in a living trust. If that's the case, then the executor doesn't have to probate the will, because there's nothing that's going to pass under the will. Everything is going to go by other means. So I guess the question is, why would you do the will anyway? Well, even if you've done all that, you still do a will just in case there was some asset that, was never POD'd, was never held jointly, it's just there, and now it needs to be dealt with. That asset that's not going to go by these other means would go under the will. So we still advise people to do wills. We even advise people, if they have a living trust, to also do a will, just in case. And by the way, if I say in my will, I want my residuary estate to go to these people, and you've done your IRA and it goes to other people, well, the people that we're going to take under the will are out of luck, because that money has already been designated in your beneficiary clauses outside of the will. I think somebody's asked me about property. Property is a special case in Virginia. Property is a very special. Virginia treats real estate different than other states. Okay, so basically, if the only thing you're having in a will, let's suppose you have a house. That's all you have, a house. Maybe you have some other bank accounts, but they've gone by designated beneficiary. And you've said, I want my house to go to my 2 children. Or you don't even mention the house. You just say, all the residuary goes to my children. In that case, you don't actually have to, you probate the will. That is, you bring the will to the clerk's office. You have it formally recognized, and filed in the land records, but you don't have to open up an estate to somehow get the property, the real estate, to the heirs. You don't have to do that in Virginia. Because the will, Virginia says that the will says who the heirs are, the property drops to them immediately. They own the property. So now, there might be other property that you have, a brokerage account that hasn't been designated with the beneficiary, that will have to be probated. So that money, you'll have to formally open up an estate, the executor will have to form it and go through the probate process. Whatever that, we'll talk about that some other day, and deal with that property to make sure that that money goes to the beneficiaries under the will. But Virginia just treats real estate a little bit differently. Now, you could say in your will, and sometimes I do that, and I talk to clients, well, what happens if you die? Do you want your 3 children to own your house? Because they're going to own the house as soon as you die. If there's no spouse, they're going to own the house. Well, no, what I want really is I want my executor to sell my house and and distribute the proceeds. You actually want to put that into the will. You want to say that the executor is to sell my house or sell this real estate and then distribute it under the residuary clause. And by the way, you actually have to give your executor the power of sale. You have to specifically say, I give my executor a power of sale over the real estate to do that. That has to be in the will. That comes as one of the powers. So you do want to have that discussion if you've got real estate as to what you want. Do you want your 3 children to just own it equally, own that property equally? Which means if they own it equally, then when they go to sell the house, they all have to agree on the real estate agent because they all own it. They all have to agree as to the sales price. They all have to agree. They all have to sign off on the deed to go to the buyer. All that has to be done. Or you could say, no, my executor is to sell my house under the probate process and then distribute the assets. So that's a discussion that you have to have with your lawyer. You need to discuss that. Now in Maryland, that's not true. In Maryland, you still have to probate the will and there's a formal process to get the property to the heirs. It doesn't work that way. But in Virginia, we just treat real estate differently. And don't ask me what other states do that because I don't know. I just know about Virginia law. DC doesn't treat property that way. Maryland doesn't. Virginia does. Okay. So I'm not sure what time we have because I'm looking on my phone and I can't really tell.
And it's we have about 10 minutes.
Oh, well then let's take questions. Okay. I can't see the questions. So if Elizabeth, if you can read the questions, sure we have some.
The real estate was the last question, but we can certainly, if someone has a question, you can unmute yourself and ask at this time. Or if you need some further explanation of what is said, I'm sure that Ed would be happy to repeat.
Yeah, I had a question about the executor. If the executor does not live in Virginia, are there extra requirements for an executor?
Yes. So if the executor does not live in Virginia, the probate office is going to say, we need a Virginia personal representative of the estate. And the personal representative is there in case there's litigation against the estate. There has to be somebody in Virginia who will accept service. So usually what happens is you'll find a Virginia, if an out-of-state executor will find a Virginia attorney, and the Virginia attorney will be the personal representative. But that's a very good question. Otherwise, you have to find somebody in Virginia who will be the person. You can still be an executor out of state, but you must have a personal representative in Virginia. And that person is there because if there's litigation in Virginia, the litigator has to serve somebody, and the personal representative is in Virginia and they can be served. That's that purpose. Okay? Good
Yeah.
question. What
Thank you.
else? No other questions?
And any other person like to ask a question regarding wills?
Yes, I have one question, and I know I may not get a specific answer, but what would be like a range of cost to have a will done? I have a family of 4 and a house in Virginia and another property out in another state. What kind of cost am I looking at to do a will? So I
Well,
can
I'm not
budget
going to give, I don't know, because all of us charge maybe different prices, and we're not allowed to compare. We're not allowed to get together and say, what do you charge? What do you charge? We can't, there's a rule against attorneys fixing prices. So I don't know. I don't know how much other attorneys charge for their wills.
Thank you.
What you should know is that when you go to an attorney to do a will, you should also do, and this is a lecture for, you also do power of attorney, medical power of attorney, a living will. You need to in some way do those other 3 documents and make sure you have that. So it's not just the cost of the will, there's these other documents that you want to make sure you have. Most people know about that now because we attorneys have been talking about it a long time, but you should expect, if you don't have it, to have the attorney talk to you about that. They better talk to you about that and make sure that there's those documents in place. So there's another cost there, but that's got to be done.
I just have a general question.
Sure.
I've spoken to 2 different attorneys about doing a will. And in both cases, they've insisted that I do a will, a power of attorney, and a medical power of attorney. And I just want to do a will right now. I don't want to have to worry about a power of attorney or a medical power of attorney for other things. I can deal with that once the will is completed and filed. Can you tell me why these attorneys would require all 3 documents and not just do a will?
Because if, in my opinion, if you're an attorney and you neglect to do the other documents, and people come after that and say, why the hell didn't you do these other documents? Why do we now have to file a guardianship? It's all because you didn't do these, and now we have to pay all this other money. I don't want to be that attorney in trouble like that.
Okay. Thank
Okay.
you. Yes,
That's why.
thank you. Thank you.
Ed, one other question, and that is of the 4 items, is there a specific order sequentially to do them in?
Yes. So you have the introduction that I talked about. You can have personal information. This is my married, this is my spouse, these are my 4 children, this is the date of births. Then you will get into the personal property, something about how you're dealing with personal tangible property, excuse me. Then you'll deal with the specific bequests, if there are any, and then you'll deal with the residuary clause. And then you'll deal with so that's how I do it. That's how most attorneys do it. So there's kind of an order sequential kind of thing. And then the rest of all the rest, powers, taxes, lapses, all that other stuff. Anything else? We still have about 10 minutes, don't we? I think.
Yes. Yes, we do.
All right, so I'm willing to talk about some other things outside of the will a little bit, if you have other questions.
I know that you're doing a program later on living
Trust.
living
Okay.
trust. Could you just tell us briefly what a living trust is?
Well, that's a good idea because I can also talk about a will. there's two, well, there's many different, but there's two basic kind of trust. One is a trust that comes out of your will. So people will frequently can, or not frequently, but you can do a trust that comes out of your will. That's called a testamentary trust. That trust doesn't go into effect until your will is probated. Okay? So for various reasons, you might do a will, and you might say in your will, well, if my children are minors, then I've done this trust in my will, and the money is to be held, assets are to be held in trust for my children until they become 18 or 25 or whatever you want. That's frequently done for families that have young children. Okay. The other, okay, and it's a little bit more complicated will because there's a trust in it, but you're going to have all of your children are grown. You may not need that. The other way is a living trust is you create the trust now while you're alive. So you create a living trust now. It's a document that is meant to, one, hold assets while you're alive so that the trustee can spend the assets for your benefit. And then upon your death, the trust says where your property in the trust goes upon your death. Frequently, people do that to avoid the probate process. Because if you get all of your property into the living trust, you don't have to go to the clerk of the court. That's often why people do it. Or they do it because it's a good way of having the trustee manage people's assets when they become incapacitated. So I had a client that I became her executor and her trustee. We got all our money into her trust. When she became incapacitated, she wasn't able to pay her bills. Well, I, as her trustee, paid her bills, watched her investments, did everything for her. So I was able to take care of her through the trust while she was alive. And now that she's died, I'm going to take the money in the trust and distribute it to the beneficiaries. And I don't have to go to the courthouse to do that. I can just write a check to the beneficiaries out of the trust and close out the account. So that's how that works. But that's a good question because I didn't want to get into testamentary trust, but probably a good thing that I mentioned it anyway, because that can frequently be a component of a trust. So you might have a will that has a trust in it for various purposes. Okay.
And
Thank you.
did we address the living will? There was a question in the chat.
Okay, well, I didn't see that. A living will has nothing to do with a regular will. In fact, I call it an advanced medical directive. And it's basically a statement as to what you would want or not want in terms of medical treatment when you reach a certain condition of health, usually terminal condition of health. It deals with about the kind of medical support you would want or not want. It has nothing to do with your assets, nothing. A will deals with your assets. That's all it deals with. That's all it deals with. Doesn't deal with your property when you're alive or anything like that. It only deals with where your property would go upon your death. That's it.
Okay, so you're saying there are two different documents, one concerning your assets and one concerning your health.
Yep.
Okay.
That's a good way of putting it.
Anyone else have questions? We still have a couple minutes.
Hi, yes, I lost audio for a little bit, so I couldn't hear, but just really quickly, Ed, in addition to the will, the other three documents that need to be done either before or at the same time are?
A financial power of attorney, a medical power of attorney, and an advanced medical directive. Now, sometimes people take the advanced medical directive and include that in the medical power of attorney. That's fine. So sometimes it's just 2 documents, but you need a document to deal with your financial assets when you're alive. If you become incapacitated, who takes over, who pays your bills when you're alive, and also who makes medical decisions for you if you can't communicate with the doctor. Now, the agent under the powers of attorneys, they lose all power upon your death. The power of attorney ends. They can't do anything. That's it. Then your will takes over. But you have to deal with that period of time when, if you should become incapacitated, you've appointed somebody to manage things for you, make decisions when you can't communicate. Okay? That's what I said. All right. Okay.
I'm not seeing other questions. Anybody else? We have just a couple more minutes. Anybody else have a quick question?
Well, if they want to hear other lectures about things, why don't they, they can put that in the chat or let Elizabeth know, and we can see if we can work them in.
Yes,
At later time.
Ed is doing another lecture, and that is February 15th, and what is a living trust? So mark it on your calendars, sign up, and you can hear more great information from Ed. Thank you everyone for joining us today. Thank you, Ed, for your time and valuable information. And we look forward to seeing everyone the next time.
Yep. Thank you. Bye-bye.
Take care.